From the time an accused person is charged to the beginning of his or her trial, several motions and procedures take place. First is disclosure, then there is a collection of evidence, court appearances, preliminary hearings, and resolution discussions. Prior to trial, the Crown must disclose or reveal all of their evidence to the defense. The accused must understand the evidence that may be used against him or her so he or she can build a defense and be granted a fair trial. The only thing that the defense must present to the Crown is an alibi defense, if they intend to use one. After disclosure has been received, a preliminary hearing is held. Before the trial occurs, the Crown and defense have the right to examine all evidence collected by the police. Evidence includes anything that may be used against the accused in court, including weapons, clothing, blood, and fingerprints. In recent years, DNA has revolutionized the use of forensic sciences in law enforcement. Evidence is often found at the scene of the crime and during autopsies. When the accused appears in court, they may enter a plea of guilty or not guilty. If they plead guilty, they are deferred for sentencing. If they plead not guilty, there may be a trial. An adjournment occurs when the Crown or defense asks for a delay or postponement in proceedings. Provincial courts hear summary conviction offenses and less serious indictable offenses. Provincial superior courts hear the most serious indictable offenses, for example, murder. The preliminary hearing is used to determine whether there is enough evidence to proceed to trial. During this hearing, a judge hears a description of the Crown's evidence and some of the Crown's witness testimony. If there's not enough evidence to justify a trial, all charges against the accused are dropped. The Crown must establish a prima facie case, that is, a justification for a trial. Resolution discussions occur between the Crown and the defense before a trial begins in an attempt to resolve the case without going to trial. This often involves an accused person pleading guilty to a lesser charge or agreeing to a lighter sentence than he or she might receive if convicted in a court of law. A plea negotiation, also known as a plea bargain, occurs when the Crown makes a deal with the accused, a guilty plea and/or additional information in exchange for a lighter penalty.